3-day notice to vacate, what every tenant should know. If you are unable to pay your rent, your landlord has to do certain things before you can be evicted for not paying. The first step the landlord must take is to give you a 3-day notice, requiring you to pay rent or move. The landlord may hand deliver the notice, tape it to your door, or mail it to you. When the landlord mails a notice or requests payments to be sent to a P.O. box or out-of-town address, they must add an additional 5 days to the deadline to allow for delivery. The 3-day notice must be in writing, tell you that you did not pay rent when it was due, tell you the exact amount of rent due, include the name, address, and telephone number of the landlord, give you 3 days to pay the rent or move. The 3 days does not include weekends, holidays when the court clerk's office is closed, or the day the notice was delivered to you. The notice can only demand payment of rent. Charges for late fees, security deposits, and repairs are usually not allowed unless your written lease agreement says they can be considered rent. Your landlord must take the rent if you offer to pay the entire amount within the 3-day deadline. Be sure to get a receipt and bring a witness. Once the landlord accepts the rent, you should not be evicted. If you only made a partial rent payment, you should receive a new 3-day notice. This means you have 3 more days to make the full payment before an eviction can begin. If your landlord files for eviction, you will receive a copy of the eviction papers. The lawsuit must be served to you. If you cannot be found for service, your landlord can tape a copy of the lawsuit to your door. A courtesy copy will also be mailed to you by the clerk's office. It is illegal for your landlord to try to evict you without filing a lawsuit. Florida law says that a landlord cannot turn off the utilities, change the locks, remove a tenant's personal property, or otherwise restrict access to the home to try to get the tenant to move out. Once you are served the eviction papers, you will have 5 days to file a response at the clerk's office, or the judge can evict you without a court hearing. The 5 days do not include weekends, holidays, or the day you are served with a summons and complaint. When you file a response, you must also deposit the rent owed to the court registry. If the rent is not deposited this way, you may still be evicted. If you do not agree with the amount the landlord says you owe, you must file a document with the court called a motion to determine rent within the 5-day deadline. If you have already paid all the rent claimed by your landlord, you should attach your receipts to your response to the lawsuit. The court will determine if a hearing is necessary. However, if you do not pay the amount owed or file the motion to determine rent within the 5 days, the judge can evict you without a hearing. If this happens, you will be served with a writ of possession and you will have to move within 24 hours. Contact the Community Legal Services of Mid-Florida Helpline at 1-800-405-1417 if you need assistance or have questions.